Okay. There's been a lot of conversation about the OSB and how it sort of compares to the Singapore. It's called the Singapore Protection from Online Falsehoods and Manipulation Act 2019. Now, some of the I think Learn Asia had put out a statement last year that many provisions of the new bill appear to be modelled on Singapore's POFMA. However, there are significant differences, and you mentioned the religious aspect. So, unlike in the Singapore Act, the Sri Lankan bill includes a subset of offences which are related to religion. For example, disturbing a religious assembly by a false statement, Section 15, and communicating a false statement with deliberate intent to wound religious feelings. So this sort of brings us back to, and you mentioned the bad faith application of these laws. So you mentioned Razmi Razik, and there was the comedian Natasha Surya, there was Arnav Jazim, who was the poet from the post-Easter attack case. What do these 2 or 3 arrests, for example, and we can mention Hejaz's Bull as well, specifically if it refers to this, but what does that tell you about this, what you mentioned, the bad faith application of this law? Is there some, so if they're not specific, and for example, in the OSB, who has the power to determine whether someone's safety, online safety, has been attacked or put at risk? So what is the institution that's in charge of this? Because the way I see it, what we're essentially saying is someone has to be the arbiter of the truth. Or you have to say, this is not false, this is true. How are we going about this in Sri Lanka? It's a very complicated thing.
So you asked about the purpose of the law, and I got carried away answering part of the question, but I didn't answer that question. Let's go to the purpose of the law. So the law is termed online safety. Okay. So let's assume, to begin with, the overall purpose of the law is to advance or promote online spaces as safe spaces. Okay. Now, let's look at how the Supreme Court views this law in its determination. And there are some passages that are actually very, very important in the Supreme Court determination. The Supreme Court kind of raises the question, well, this is about online safety, but it doesn't seem like certain phenomena that might be associated with the lack of safety, like phishing scams, like cyber attacks, like, if I were to expand that list, things like malware, spyware, denial of service attacks. None of these things are featured in the bill. None of these features. So then immediately you have the question, is this really about online safety? Instead, what the bill actually does is replicate a bunch of Victorian penal code offences that we've had in our penal code since 1880s, and adds certain language into that, like false statement, online space, and sort of tweaks these offences, and now says these are the offences that are covered in the bill. So really, it's not advancing online safety, and the Supreme Court is absolutely right to point that out. And you mentioned wounding religious feelings. That's an old offence that's in the penal code. What they've done is they've replicated it almost word for word and added certain elements like, wounding religious feelings through a false statement and wounding religious feelings through a false statement in an online space, right? I mean, the original offence in the penal code is broad enough to capture both false statements and online spaces. You don't need to actually include it in a new law, right? It's already a very broadly worded law, and in fact, people are arrested and charged under that penal code offence as we speak. So the question might be asked, what is this new law actually adding, right? Because people currently are prosecuted or charged under the ICCPR Act for online statements. They're charged and prosecuted under the Computer Crimes Act for online statements. And certainly the penal code, all these offences are currently in use. So then the question is, what is actually the addition? What is the value proposition? So again, the Supreme Court makes a very important observation on this very clause that deals with wounding religious feelings, and asks the question, well, what does this have to do with online safety? And the act that is finally brought into operation through the Speaker's certification has somehow retained that offence, without paying heed to the Supreme Court's determination that this particular inclusion is deeply problematic. And actually things like phishing, things like spyware, malware should have been what is included. So in a context where the Supreme Court makes this very apparent and makes its criticism very apparent, the Online Safety Act retaining these offences, these Victorian-era penal code offences, in sort of tweaked form, is deeply problematic.
Dr. Gehan, just for our audience's benefit, you're here representing the Human Rights Commission of Sri Lanka. But some of the questions I ask you, you may have to just
no, absolutely,
talk more generally.
Thank you for raising that.
Beyond your remit.
Yeah.
So I just wanted, you just mentioned this wounding religious feelings, which seems to be a big part of the OSB.
Yeah.
Where do you go from wounding someone's religious feelings to incitement? How do you connect the two?
That's a good question. So,
because I just wanted to clarify, if I'm personally hurt or upset by something someone says, I don't think I have legal recourse to anything.
Yeah.
Right? Unless I can show that I've been hurt or made some sort of income lost, or how does this,
so
at what point do I then incite people? I mean, how does this?
So this is a great question. There is a vast difference between wounding someone's religious feelings or offending someone's religious sentiment and incitement.
Right.
Unfortunately, our law criminalizes both things. Our penal code was framed during a time when the British were absolutely preoccupied with public order. And they knew that communities are quite sensitive about religious sentiment. So they're not interested in developing sort of coexistence and creating harmony. What they do, they're interested in maintaining public order so the commercial enterprise of the colonial state can continue. So wounding religious feelings is criminalized.
Right.
Going into someone's religious space and desecrating their religious object is criminalized. So they approach this issue, this challenge, through a criminal law lens, because they can't be bothered doing anything else. And the best way to manage these natives, quote unquote, is to criminalize their activity and then punish them if they fall out of line. Because they anticipated that if they don't, there'll be a lot of contestation, violence, conflict. And that was the case. There was quite a lot of conflict on religious lines during that period. We weren't the sort of model colony that sometimes people claim we were. There was a lot of contestation. Now, that kind of offense was never taken out of our statute books. They are retained even today. So if someone was to wound or outrage religious feelings, there is a possibility that person would be prosecuted under the penal code. But unfortunately, instead of being prosecuted purely under the penal code, they are prosecuted also or charged also under the ICCPR Act. Section 3 of the ICCPR Act, which deals with incitement. Now, that's a completely different ballgame. Incitement is where I say something to you to actually provoke you to attack another person on the basis of that person's national, racial, or religious identity. So that's a higher threshold. Just saying something that wounds that person's religious feelings doesn't meet the threshold of incitement. I actually have to gather other people and convince them that this other person is a danger or this person should be targeted. And I'm so influential that I'm able to actually incite violence or discrimination or hostility against that community. So just merely wounding someone's religious feelings or saying something offensive doesn't meet that threshold. What meets the threshold would be a statement, by a powerful political actor or religious actor telling his community or her community that this other community is bad news, or they're alien, or they're controlling, the market, and we need to attack them. We need to boycott their businesses. As if that hasn't happened in this country.
Right.
It has, but no one actually gets prosecuted for such statements. So it's really quite bizarre that we have this law on incitement that is both over-inclusive and under-inclusive. Over-inclusive because it includes things that have nothing to do with incitement, and under-inclusive because it seems to surgically exclude things that amount to incitement.